Thank you, Kristen. Thank you so much for the introduction. And right off the bat, I'd like to thank this extraordinarily distinguished and expert group of panelists, Ashley, Steve, and Daniel. I don't think we could get more expertise on this extraordinarily important topic of corruption in general and FCPA enforcement in particular than the group of three that we've gathered here today. So let's get started. You know, one of the things we pride ourselves upon at Stanford is we try to be very data-driven. We try to deal with facts, not rumors. And we've collected a large amount of information on our FCPA website about actual real world trends with regards to FCPA enforcement. And Steve has been working with those data, and we put together a bunch of slides so that we have some empirical information that we can share. And Steve, why don't you turn to that, and why don't you just, illuminate us about what the trends are, why they appear to be going where they are, and then more intriguingly, where do you think they're headed in the future?
Yeah, so thanks, Joe, and thanks for including me in this panel. I think the data is relevant and informative. I think there are a couple things that are worth sort of mentioning for context. The first is, we're obviously have been for the last 18 months enduring an unprecedented global pandemic that has had far-reaching effects. And I was at the commission for the first I guess about 6 months of the pandemic, and it was incredibly disruptive, obviously. Until recently, commission staff has not been even permitted to return to the office. I think now they can attend on a voluntary basis. Investigations originally really slowed down because people were out of the office. We were adjusting to try to figure out how to take testimony and collect evidence remotely. People had competing obligations of caring for family members, et cetera. I think by the time I left last summer, things had started to reach a period of relative normalcy. And that normalcy has increased, over the last year or so. And so, while I don't think things are back to the way they were before the pandemic, I think the Division of Enforcement is functioning, at a pretty high level, under the circumstances. I think FCPA enforcement probably has been, impacted significantly by the pandemic, and particularly because of the cessation in foreign travel. The F, as I like to remind people, in FCPA stands for foreign. And, a lot of the cases are driven by corporate investigations where, lawyers are, traveling all over the world to interview witnesses and the like. And, the FCPA folks at the SEC and DOJ, likewise do the same. And obviously that has been disruptive. The other thing I think is important to note in assessing sort of the facts and figures is that, FCPA cases have a very long gestational period. I think, they're among the longest enduring investigations at the SEC, and I think probably at the DOJ as well. And they're lumpy. They come sort of to completion when they come to completion, and episodically. I think, there is a driver, the end of the fiscal year is a driver to sort of get people to, put the pedal down and try to get things across the finish line. And I think, we've seen that in a sort of flood of enforcement cases that have been announced in the last week, and probably some more coming today.
So Steve, you're basically saying that the enforcement division needs to make its quarter just like a CFO.
Exactly. And there's no 35-day month permitted, no computer associates type behavior, you got to get those
favorite lines. December 35th. I mean, that's one of the great lines in the history of Silicon Valley.
It's, and I will say, just parenthetically, it was a point of pretty significant frustration for me because there are a lot of people out there, Congress, the press, academics, who measure the effectiveness of the SEC's enforcement program by how many cases did you bring and how large is the pile of penalties and financial remedies that is assessed. And I think that's a crude, it's a crude measure, and sort of can drive, the wrong sort of behavior. It can incentivize you to sort of push a bunch of stuff across the finish line so that you don't have a number that deviated a lot from prior years, and you don't get accused of being ineffective or weak. But I think as any sort of clear thinking person knows, the number is not really a measure of the effectiveness of a program. But I live in the world, and so we spend a lot of energy making sure that the activity levels in the enforcement division stayed relatively constant year over year. So that being said, I think we have seen a drop in FCPA matters, and I think maybe if we show the first slide, we can see that illustrated.
It's pretty dramatic in my view.
So if you look over time, you'll see that there is variation, but very high numbers of individuals charged in 2018, 2019, and then, or I guess starting in 2017 through 2020. And then, in 2021, obviously pretty significant fall off to date. And we see the next slide, and then we'll talk about what this all means. And, in terms of, that there's a very small data set in 2021, but you see basically rough parity between domestic and foreign entities that are subject to FCPA action. Next slide, please. We've seen some, matters announced here recently. There are a few ticked off here. And then let's go to the next slide. This one is interesting. Newly disclosed FCPA related investigations per year. Obviously the Stanford looks at public disclosures, and you see, a very small number announced this year, and pretty good fall off from 2015 to 2017. And I frankly don't know why that is. I can tell you, at least while I was at the SEC, the level of activity in the FCPA unit in terms of the number of investigations that were being opened and pursued was relatively constant over the time that I was there. There was no effort to, withdraw resources. So I actually have a pretty hard time explaining, this decline. And,
Well, Steve, so one of the things that's interesting is one of the innovations we have at our FCPA database is all of the other people that follow this space. Historically, what they've done is they've looked at announced actions. Well, one of the things my colleagues and I figured out is, you have leading indicators. And as you guys well know, sometimes companies will disclose the fact that they've received subpoenas, there's an investigation ongoing, and that allows us basically to smell cases that are coming up in the future, even before there's an article, even before there's a proceeding that's brought and what have you. And it's these data indicating that there might be a sharp drop-off in terms of actual internal investigations, because I can't think of a systematic reason why companies would now be less likely to disclose if they know that there's an investigation going on than before. I mean, Steve, Aisling, Daniel, any views on that?
I don't want to hog the airtime. Aisling?
I mean, we really don't know. It could be any number of factors, including one, there may be disclosures that are more general so that it's not sensitive enough to get picked up in the data. Two, Steve talked about the impact of the pandemic. So there could have been a drop of initiation of new investigations and or companies identifying and self-disclosing things. Three, it just could be the sort of cyclical nature of the beast and have no significance whatsoever. So I think we'll have to continue to track the data, as you mentioned, over time to see what happens to the number of actual actions, because I think you're right that these disclosures can be a leading indicator, but they're not always the leading indicator. And I think because of, as Steve noted, the extreme length that these investigations take to come to fruition, it's just too soon to write the story based on an analysis of public disclosures.
Yeah, I think the cases that you saw sort of concluded in the last year were probably primarily the result of work, investigative work that was done before the pandemic. And so now I think, as you sort of see a case like, something traveling through the body of a snake, right? Like now I think we may be seeing the results of the fact that, there was a lull in investigative activity. And so right now there isn't a lot of ripe stuff ready to be concluded. But I will say, my view is that, those predicting the end of FCPA enforcement, are likely to be disappointed for a couple of reasons. First of all, there are substantial dedicated resources on the government side. And, those people are going to come into work and they're going to do investigations, both at the DOJ and the SEC. Secondly, there's a huge apparatus built up in the legal and compliance establishment and investigative establishment of lawyers who, make their living doing this stuff. And I think they will, find things to do. And clients are obviously incredibly, sensitive to these issues. And then the third, this is a little bit of a cynical view. I mentioned before that, there are some that will measure the effectiveness of these programs by, the total amount of penalties, disgorgement, fines, forfeiture, et cetera. And FCPA is a big contributor to those numbers. And, if you look at the total amount of financial remedies that the SEC, imposes in any 1 year, say it's, $4 or $5 billion, a pretty big chunk of that comes from, hefty FCPA resolutions. So I think that there's sort of an institutional interest in continuing that activity.
No, absolutely no doubt. So one of the larger questions here is if you look at the data that you just presented, Aisling in particular, if we look at starting around 2018, there appears to be a drop off and COVID didn't hit until 2019. So it's hard to blame the drop off that starts in 2018 on COVID. Right, in 2019, although I'm sure there are people that are doing it with everything else that's going on in the world. And any insight, is that just a blip in the data that we should ignore, or is there deeper meaning there?
I don't really think we know. And with all due respect to the database, which I think is an extraordinary resource, I think we've seen, if we've looked at the history of the enforcement of the statute, that the sort of statistical and quantitative analyses really only take you so far in understanding the story of how enforcement under the FCPA has evolved. So I don't think we can say right now. It may be that we come in time to understand and think this was a meaningful trend. It may be we decided something that appeared to be a trend at the time, but actually if you look later at the pipeline. So I just think really looking at the quantitative statistics only gets you so far in sort of understanding the full story.
And moving from that detail to a much bigger, moving from like a 3-foot view to a 36,000 foot view, the White House on June 3rd, relatively recently, issued a memorandum on establishing the fight against corruption as a core United States national security interest. What's the practical implication of this White House memorandum, if any? Is this, they wanted to issue a memo, okay, we got a memo, we have talking points, or is something in the real world really going to change because of this memo? How do you see this?
Sure. So I think it's a little bit of a stay tuned and a little bit of forecasting, because the memo calls for a 200-day interagency study on what can be the practical implications. But by my count, that means the study should be dropping right around Christmas. So that will give us all a holiday present to pour over and wonder about the significance of. So I think it will be really important to see the detail that comes out of that study. But in terms of sort of forecasting, you have to imagine that the President of the United States directing every agency of the federal government to up its anti-corruption game, which is what a White House spokesperson said on background when describing the National Security Study Memorandum, that is going to have a very tangible impact in how those agencies respond. And as Steve mentioned, there are already dedicated resources focused on the FCPA of both DOJ and SEC. Is this declaration about the fight against corruption being a core national security priority going to result in an increase of resources to those units? The DOJ also has the anti-kleptocracy initiative relating to the proceeds of kleptocracy, which I think if you look at the National Security Study Memorandum, it's taking a very broad view of corruption that certainly includes the FCPA, but is not limited to it. And tellingly, there are a lot of agencies who have been directed to be involved in the interagency review, and it's written at a very high level. So I think that another thing to sort of stay tuned for are perhaps non-traditional sources in terms of the government stepping up and sort of announcing what their role in the fight against corruption is going to be. FinCEN declared its anti-money laundering priorities shortly after the memo came up, and corruption was either, I think, first or second on that list. So I think we're going to need some time to see the sort of nitty-gritty practical implications of it. But I think as a shot across the bow, it's difficult to imagine it's going to do anything other than increase overall enforcement. I think another really interesting thing about the National Security Study Memorandum is how it treats work with partners, both domestic and international, focusing on building international partnerships, which I think, after having said I don't believe in that many trends, I think that is a real and very meaningful trend, the increase in international cooperation that is only going to increase, improving foreign assistance, helping to provide US resources to other countries in their own fights against corruption. So I think we really need to stay tuned for the details, but I anticipate that this is something that is going to have a meaningful real world impact on how enforcement is handled, both at the US level, but also at the international level.
So let me push back a little bit. I think the effect, if any, is going to be sectoral in the following sense. So much time and energy has already been devoted to FCPA enforcement that I can't really imagine that this statement is going to change anything at the margin with regard to FCPA enforcement, or that the change would be significant. On the other hand, if we look at the area related to crypto, and if you start thinking that the use of certain forms of crypto is highly correlated with other forms of corruption, then I can see the government evolving new processes and starting to look at crypto through a very different lens and saying, well, we need to do something, all right, about crypto because it's facilitating ransomware, it's opening up our infrastructure, and it's facilitating corruption, all right? So I actually see a very, very differential effect depending upon how you define corruption. Marginal influence on FCPA, where there's an existing infrastructure, people know how to do this. Much stronger influence in areas like crypto, perhaps AML, KYC, where you can imagine more evolution along those lines. Does that make sense, Aisling?
No, it makes sense. And I think that the memorandum, and we'll have to see what the study says, certainly takes a broad view of corruption. And I think you're drawing a very interesting link, which is the memo draws a straight line from corruption to national security concerns. And the next question are, what are all going to be all of the things that you now draw a straight line from corruption to, both in the categories that we would traditionally think of as anti-corruption related enforcement efforts, as well as in things that we wouldn't traditionally think of.
So
yeah, I think, Joe, your observation is I think a trenchant one, which is that the FCPA program, at least from my observation, is a very mature and developed program. I think there are probably some changes, modest, that occur year over year, but it's pretty much a machine that runs. And I don't think, you could obviously add some more bodies to the FBI and the DOJ and the SEC groups that are pursuing FCPA matters. But it's hard to really, I think, work seismic change on the program.
I think that's right. Now, on the other hand, you look at issues like crypto, there's nothing that's really established. The government has no idea what it's doing. In the zip code in which I'm out here, it's like every one of my neighbors has got their own DeFi project. And comparing what's happening here with what people understand in Washington is kind of frightening. Washington is so far behind that it's just really astounding. Now, Daniel, you live with these issues in the real world from the corporate perspective every day. All right, this is in your bloodstream. So the question about what are the implications of the White House memo? How might this get strengthened? And what are corporate expectations around anti-corruption compliance? What are corporations doing? How are they upping their game? What's changing? How do you see that from your perch, Daniel?
Thank you, Joe. I think I think we cannot argue on what the memo means at this point, and I think we all agree on that at a certain point. But I think something that changed dramatically in the last few years has been the level of expectations that not only the authorities but other stakeholders are having on companies. I mean, you sit on boards successfully. I mean, have been doing that for a while. I'm sure that you have seen how the expectations on ESG, for example, are different than what they were 5 years ago, 10 years ago. The expectations on what is the culture that your company has. And that change in expectation is also related to change of ways of doing business. I mean, many companies are having to reinvent the way they do business, or because they learned something during the pandemic, or because their business model is changing in any case, as the world is changing. So I think that you have the authorities on one hand, that they have to continue evolving their game, and I think that they are. On the other hand, I think that you have a lot of other stakeholders, I mean, starting from customers and different groups, that they are seeing, they're expecting more from companies. And you see, when you go to see the Fortune 500 today, well, you see that some companies are better equipped than others in terms of what are they doing, starting at the board level, just to say, okay, how does it interact the word trust and the trust that we have to gain from the authorities, from the customers, from the people that we want to join our company, and many different stakeholders. How does it interact as well with the culture that we have, with the way that we manage ESG, with the way that we have a compliance program, including an anti-corruption program, and with the way that we manage risk overall. So all those things together, I think that companies, I don't know if we can call it that they have an opportunity, but I have to say, I think it's going to be a must that they have to see all those things holistically, and they not only have to be trying to defend themselves from whatever are the enforcement actions that they are seeing from the authorities and the trends, but they're going to have to build something more than that. They're going to have to get ahead of it, because otherwise they're going to be losing trust as well, which for many companies, that could be the end.
And Daniel, I agree with you entirely. And let's try to take these concepts and let's concretize them. Let's make them realistic. So if you had to give corporations 3 pieces of advice, how we're living in this evolving environment, what can and should corporations do intelligently to position themselves in light of all of this evolution? What would you recommend?
Well, number one, and I love the question. Number one, I would say you have to be sure that you have people at the board level and below that they are having these conversations, that they are talking about that interaction and connection between building trust, having the right culture for the company, having the right compliance program, I mean, managing risk properly. You have to have that starting at board level. It's not enough to say that you have a group of people 2-3 levels under the GC or the chief compliance officer that are doing that. That starts at the board level. So that would be number one. Number two, I would say that that has to be the way that you are doing compliance, the way that you're driving that trust in the different stakeholders has to be revisited the same way that you revisit your business model. You cannot expect that you're changing completely your business model or everything is changing around you and you still have the same compliance program or anti-corruption program. That's not going to be effective. So effectiveness is key. So that would be the second one. And the third one, I would say, I think that it's really ensuring that you know what others are doing, because there are different companies in different industries that have gone through this and that they are doing a really good job. That doesn't mean that exactly the same thing would work for any company or any industry, but I have to say spending the time and the energy on doing good benchmarking with the ones that already have done a good job on this. Those would be my 3 points.
I think that's exactly right. And what I'd like to do is sort of expand, dive in a little bit on it and expand in a couple of different directions. So your observation about, needing to look at this at the highest level, at the board level, let me emphasize how right I think you are, because if you have a look at the recent opinions out of Delaware having to do with the application of caremark liability, the courts are basically saying, well, did the board have a committee? Did the board look at this? Did it have any procedures? If it didn't have the procedures and it becomes a big problem, your index of concern is increased very significantly. And then even if you have the procedures, if you don't implement them appropriately, again, your index of concern, right, is substantially enhanced. So I would think that for any company that's doing business in fragile jurisdictions, in jurisdictions where you have reason to be concerned about FCPA violations, and again, our database will help you quantify exactly which those jurisdictions are, you better have these procedures in place, and it is a plus if it reaches up to the boardroom level. So Steve, Aisling, any views from your perspective in terms of how you counsel boards on this?
So, I mean, I think like this isn't really distinguished from any other, potential corporate crisis, right?
Exactly.
The corporate crisis, I was just on a panel about corporate crises, so I've got in my mind some smart things to say that I'll crib from other people. But, corporate crisis is something that poses, existential or transformative threat to a company. And as we've seen, FCPA cases, in the extreme can be, meet that standard easily. And so, not every FCPA issue rises to the level, right? You found somebody gave a Christmas present to a government official in China or something like that. Okay, that's one thing. But then we've seen obviously endemic corruption that has, shaken companies to the core. And, boards have to be highly sensitized to the risks associated with this.
Aisling?
I agree with that. And I think further to the point that Daniel made, it's about seeing these governance and risk issues holistically, thinking about them before you're in crisis mode, being sensitive and engaged. I think Daniel also made another very important point, that there is no one size fits all solution to anti-corruption compliance or risk management, and thus there is no one size fits all solution to governance that includes those issues. And so I think, all of this needs to stem from, meaningful risk assessment and letting risk assessment sort of drive what happens to manage those risks. But I think getting boards and senior management sort of engaged and sensitized to these issues early, and making everyone smart on these issues before they're facing a crisis really, really, really helps, because in my experience, the boards that have already had those discussions, gotten regular briefings, sometimes gone through training that themselves are much more ready to hit the ground running in the scenario that Steve articulated, where you're facing a major crisis, because they're better steeped in the background. They know how things are supposed to work, and they've really been involved in the ownership of it. I think Daniel also made a great point about the companies that go through these situations most successfully are those that take them as an opportunity for really sort of long-term remediation and betterment. And there is probably a lot to be learned from the programs that stem from these kinds of crises.
So let me drill down. I think this is all great. Let me get to some really practical questions that I know have come up in my experience and are really tough ones to deal with. Number one, when should companies self-report? Steve, you want to grab that one?
Yeah, I mean, I personally think that the calculus on self-reporting has changed in light of the sort of success of the FCPA of the SEC's whistleblower program.
Absolutely.
I think I had one experience myself where got a very detailed whistleblower letter sent to the company. We were engaged to go try to figure out what we could about whether the claims were correct or not, and actually did a bunch of field work over a few months found out that there were significant mistakes and misunderstandings on the part of the whistleblower. And, we're preparing to have a discussion about, in light of those conclusions, should we bring this to the attention of the authorities? And before we could do that, a subpoena showed up because the whistleblower had gone to the authorities. And so, we were moving pretty quickly and still couldn't outrace the whistleblower. I think companies now, have to have one eye on the fact that, their, opportunity to self-report could be taken away from them. And I think it just tips the balance more in favor of self-reporting than existed, even a few years ago.
Daniel, how do you think corporations are looking at this issue?
I think that every case, as you know, Joe, is different on this respect. But the truth is that I feel that if the company wants to be transparent about what is happening and what are they doing, and at least what I have seen is that the level of collaboration that comes after that, it is different than when it's the authority knocking at your door. I mean, the same thing when you're managing monitorships. I mean, it's exactly the same thing. A monitor, you have seen the same monitor working for two companies at the same time, with one going really, really well and with the other one not so much. But that has a lot to say in terms of what is the level of collaboration that the monitor perceives when they are interacting with the board, when they are interacting with the senior leadership. I mean, and it's that there's a big difference between having a program that works and having a program that works that is highly supported by the leadership. I mean, and that is part of the culture and the way of doing business. There's a huge difference. And so it really depends. I think it's meaningful to understand the history of the company, where the company is at that moment. It would be probably unfair to tell you, Joe, that it is a one or the other one. I think it really depends.
Right. Aisling, what's your perspective on this self-reporting issue, which I know is every time a problem comes up, this is now stapled to that question as well.
Right. And I agree with Daniel that there certainly is no right answer. And I agree with Steve that the window is much shorter than it used to be. Steve spoke a bit about the SEC Whistleblower Program. I think under the FCPA corporate enforcement policy and the pilot program that preceded it, obviously the DOJ has done everything it can to stress the importance of self-disclosure and to make tangible, the incentives to self-disclose in these cases. And I think on the timing front, in a lot of the speeches and panels that followed the implementation of the corporate enforcement policy, a consistent message that I think we've heard coming out from the DOJ is, don't wait until you know everything. We understand that you may not know everything on the first call, which again, all counsels towards the signs that are being sent from the government are, make the first call when you feel that you can, and don't wait for everything to be tied up in a bow. And I agree with Steve, this can be a very, very, very stressful decision for companies because it feels like a very high stakes decision. And it's one that unfortunately needs to be made very, very quickly, because if you want to reap both the tangible and intangible, as Daniel articulated, benefits of self-disclosure, you don't have much time to decide whether to do it because it could be taken away from you at any time. So I think there is no right answer about whether to do it or not to do it, but I think it is an analysis that you need to work through very quickly, and unfortunately, probably before you have bottomed out all the facts and before you have a clear understanding of exactly.
So let me share the perspective that I've evolved to. And again, this is an evolution over time. This is not what I would have said 10 years ago. I now begin with the presumption that at the earliest time you have credible reason to believe that there's a problem. The presumption is we then self-report. And you can self-report by going in and not by saying, look, we have an FCPA violation. Rather, hey, we have a report that's come to us. We haven't investigated it. We don't know what's going on. We're going to go out. We're going to hire an expensive law firm. We're going to pay a lot of money. You're going to do it anyway. All right. This is what we're going to do. We'll report to you what it is that we find out. But this is the earliest notification that we're getting that is credible at a particular level. And you go to the government with that, you're going to get maximum credit for that, even if the person has already filed a whistleblower complaint. All right. if you're able to demonstrate we acted promptly, you're going to get max credit. Then what I do is I say to people, all right, we're going to begin with that as the presumption. Now, you tell me why we shouldn't do it. If we begin with self-reporting as the presumption, given the current equilibrium in the market, and especially the fact that people can make $100 million now, you can make more money as a whistleblower than you can as a partner at Sullivan & Cromwell. All right, you know, that's remarkable. All right,
depressing. It's depressing, Joe.
Absolutely. That wasn't the world 10 years ago. Now it clearly is the world. So the counseling that I'm giving is I begin with the presumption of self-reporting, and I ask everyone in the room, give me your best argument to talk us out of it. And over the last few years, we start with that presumption and we wind up self-reporting. And it turns out fine.
I tell you, Joe, I mean, I tell you, if I am serving a company, I mean, I would like to have a board member that would make exactly the point that you just made, quite frankly. I mean, as a chief compliance officer of a company, what you expect, what you want is to have a board member that would be sitting there and making exactly the argument that you made. That is perfect to me.
And you know, when companies call me in as an advisor, when I'm not sitting on their boards, that's the advice that I give. You know, start with the truth shall set you free. Let's start with that.
Yeah.
Now, do we have a good reason? Do we have a credible litigation related reason or business related? You can talk me away from that presumption, but that's where we start. And what that is,
what I heard from industry and the bar was you've done a bad job of demonstrating what the benefits are for self-reporting and cooperation. It's a constant refrain.
Yeah. No, I agree. And when I have these conversations, I explain, I sort of start with, look, the equilibrium has changed. If you're using logic that you developed 5 years ago, you're out of date. Let me tell you about the new reality. And that's why, and I begin by just confessing the advice that I've given has changed. The advice I'm giving now is different from what it might have been 5 or 10 years ago. Why? The facts have changed. Right. You know, and you know, sort of a related point. Many of the companies that I deal with really aren't ready for ransomware. All right, and that's a corruption issue. And you need to know that if you're going to be paying $1 billion Bitcoin in order to get your data back and get your systems back up, there are ways to work with the government to make sure that those Bitcoin aren't going to wind up going to North Korea, all right, or to Iran. And the government will look one way if, all right, it's going to wind up back with the Russians, all right, you know, Putin needs another, you know, palace somewhere near the Black Sea. They tend to look the other way. But if there's a reason to believe it's going to go to North Korea or Iran or other sanctioned states, the government's not so happy about you paying the ransom. And I view ransomware as a subset of corruption. How are you guys approaching this, Daniel?
Look, it's interesting because I think now it's getting more and more, we're getting more and more used to hear cases about ransomware, but I think that there are many industries that they have been doing this for a long time. I mean, and having conversations. I mean, I'm referring particularly, for example, to the oil and gas. You know, I worked in the past in the oil and gas many years ago. And I can tell you, even before year 2000, company was dealing with that kind of stuff already and in conversations with the authorities and so on. So I think it is being transparent, acting quickly in terms of communicating to the authorities what you're going through, what is happening. But I know that each situation is different. And in some cases there is information that you are protecting or you want to protect. In other cases that people's lives, I mean, it's different. But I have to say, for me, it's that not having the approach of giving up too quickly, communicating very quickly to the authorities, but not giving up too quickly to be paying or to say in the position of the companies that we want to be paying immediately. I think, at least in my personal experience, that has been what worked best. Those two things, immediate communication to the authorities, and number two, saying, hey, before we talk about how we are going to pay, let's try to push back. Let's try to see what are the options. Let's try to understand. And I tell you, I mean, we don't have time today, but I have lived myself cases in which it looked very much like there was no way out without paying. And the company managed to do it without paying, with the authorities knowing, and everybody was safe. So it could be done. I've seen it. It could be done. But I think you need to be working as a team with the right people as well.
Yep, I agree entirely. And it's a topic for an entirely separate conversation. We can have a whole separate webinar about the realities of ransomware. And it's really far more fascinating and nuanced than most of the stuff that you wind up reading in the newspapers. You know, Aisling, Steve, any views about that aspect of dealing with corruption and compliance and the like? Well, related to that, we've already talked a little bit about the Whistleblower Awards, and I think it's fair to say that those awards have absolutely exploded. It was just last week that the SEC announced that the total amount paid in Whistleblower Awards just in the SEC program has now exceeded $1 billion. And that's non-trivial. And there are people that have made more than $100 million. All right, you know, these are you know, lotto-like numbers. You solve all your financial problems, you solve your kids' financial problems, and you solve your kids' financial problems, all right, by being the right whistleblower in the right place at the right time with the right information. That's the new reality. And it cuts across corruption issues, all forms of security fraud issues and the like. And I think the implications, again, are not fully appreciated in corporate boardrooms. Steve, what does that look like from your perspective? And we've got some slides that show the interaction.
Yeah. So just, you know, I actually think that the reason for the, you know, explosion of whistleblower awards is a pretty, it's a pretty unsexy reason. You know, one of the things that Stephanie Avakian and I found when we got, you know, into our seats in the enforcement division was that the process that had been designed and put in place for adjudicating whistleblower awards was designed for a program that had a tiny fraction of the number of award claims that had resulted. And the result was, you know, a process that was unfit to address, you know, the huge volume of award claims that need to be adjudicated and a very substantial backlog of award claims. And so we spent a lot of time trying to rationalize the process and create a more efficient process, particularly for denials of awards to clear out, you know, those backlogs, because the goal of the program is to pay meritorious whistleblowers, not to spend all your time trying to figure out the reason why somebody shouldn't get paid, right? And so, you know, the effect of that, I think, has been felt over the last year, where the Office of the Whistleblower can move through the number of award claims much more quickly than it had in past. So I've just broken my arm patting myself on the back, but so here's a few slides. So first of all, number of whistleblower tips, like the number of tips, complaints, and referrals in total, has exploded, and particularly, you know, during the pandemic, for reasons that I can't really understand. You know, I think there were a lot of coronavirus-related tips, and I think there were over like 22,000 tips in 2020. But we saw an increase, you know, of whistleblower tips, you know, kind of across the board, as evidenced in this chart. Next slide, please. Can we get the next slide? Yep, there we go. So, you know, I think you've kind of seen corporate disclosures and financial statements continue to be the sort of most popular area and lend themselves most readily to whistleblower tips. But, you know, and FCPA complaints, which are large, have, you know, been pretty steady over time, remarkably steady over time.
Yeah, let me just share an observation there, if I may. In order to have a credible FCPA tip, you really have to be inside the corporation. You have to know what's going on. There's, again, and Steve, it's my impression there's a lot of junk that comes in here. And the SEC just recently, I think, barred 2 people from filing whistleblower complaints because they just filed junk.
Yeah, I think there are frivolous filers who every time the SEC puts out a notice of a covered action, they file a claim hoping to be awarded the whistleblower award, even though they had absolutely nothing to do with it. Look, there are 20 some odd thousand tips, complaints, and referrals. A lot of them are not meritorious, right? You get people come to the wrong agency, right? They didn't get their social security check and they've, come to the SEC. Or, there are some, group of, kind of the unbalanced, right? They think that they're coming to the SEC because their fillings have radio transmitters implanted in them or something like that. But there are very high quality tips. And in particular, the program has been benefited by the development of a very sophisticated whistleblower plaintiffs bar, populated in no small part by alumni of the Office of the Whistleblower. And those people understand what resonates with the enforcement staff, and they know how to package up information in a way that's very accessible to the staff and results in, high quality tips being presented.
Yeah, and generally, if you're inside of the corporation and a tip comes into you, you can also form a view as to how credible this information would be if presented to the SEC. So
Yep.
that's another level or filter that you can actually use along those lines. Kristen, do we have any questions from the audience, or should we continue with this conversation?
Yes, we do have a few questions. Pull those up. How should companies adjust their compliance practices to adapt to a world where many employees are remote and therefore harder to monitor? Daniel, maybe I'll start with you.
Daniel, I think that question has your name written all over it.
Yes, thank you. Well, the first thing to consider is to say, because of the pandemic, is your company changing the way that they're going to be operating moving forward? Because most companies have policies that are written for employees to be working in the same place. So if moving forward, your company is deciding, well, from now on, everybody works from home. Well, certainly the first thing you have to do is just go back to say, do I have the right people for that? Do I have the right policies for that? And I have to revisit those and understand if you still could be effective. The one thing to consider from the board perspective and from the senior leadership perspective overall is that there is a cultural erosion when you have full-time people working from home for a long period of time, and understanding how relevant is the culture of your company for the success of your company as well. I think it is critical. So those would be initially the first three things that I would advise a company to take a look at.
Steve, Aisling?
Yeah, I think it's something that a lot of companies are really struggling with, particularly, in the trading environment, right? Where, typically you have compliance personnel sitting on a trading floor, and now, you've had traders operating remotely. And I think it's a real struggle. So I don't know what the solution is.
Oh, I agree. I think this is, like many aspects of living with the pandemic, one of the things that I've seen so many companies struggling with in good faith. I think one point further to Daniel's point about culture and also compliance is that anti-corruption compliance, because it can be geared for a global business environment, it may be run by a central function where the sort of leadership and compliance decision making, it's sort of the opposite of the compliance person sitting on the trader floor, right? You may be, your leadership and your anti-corruption compliance may already be centralized and designed for a global workforce. So I do think that the companies who have been successful have also been looking at the sort of how they extend to the mobile work environment the sort of implementation of a global culture, when they do have people doing business in remote locations, sort of far from the mothership, which I'd be interested in Daniel's thoughts, but I think that can be a real culture of compliance concern, even in a non-pandemic time. So I think to the extent that people who have been focused on global anti-corruption compliance have already been grappling with those issues of how do you instill a culture of compliance, on every continent, if you're doing business in every continent, and I do mean literally every continent. Some companies are, you can sort of take that and modify it to, and how do you take a step further and do it on every continent when people aren't even gathered? So I think that is one interesting thing that I've seen, sort of people trying to import the compliance and cultural lessons of globalization to the remote work environment.
I cannot agree more. And that's what I said. For me, the first thing is to say, okay, let's decide as a company, this is the way that we're going to be working moving forward, or this is just for a couple of years and that's it, but then we are going to go back to normal. And the reason why I'm saying that is because we all know there are companies today that decided, well, you know what? I mean, we just close our offices. From now on, everybody's going to work from home. Well, that is a very different situation from companies saying, well, we are going through this and it may take 1, 2, 3 years, but at the end of the day, we are going to go back to normal. That's a different scenario. And I think that the revision of your policies is different as well. Joe, I mean, I know that you always like practical examples, and I can tell you one. One of the things that in talking to different colleagues, we notice is, in terms of corruption and how the risk has been elevated in many countries, is just think about the fact that there is a country X in which many government officials have corruption as a source, or solicitation of bribes as a source of income. And they have been locked down for 6 months, which, as you can imagine, represents a reduction in their income, let's put it that way. So suddenly the country starts opening up again, and your stores get hammered by, not 1 or 2 or 3 solicitations a month, you get hammered by 10. And at the same time, you're going to just reinvent the way you're doing business. There's you may not have what is required in terms of in terms of people or supplies to be driving your business, etc. And you're being hammered with bribe solicitation. So that's one thing that if I am advising a board, I would say, if you're operating in some countries where corruption is high and it's in the streets and it's happening every day, you just have to consider that there's a lot of people that live out of those bribe solicitations, and you're going to get hammered more than what you were before with those solicitations.
Absolutely right. Kristen, any other questions?
Yes. You've discussed the impact on corporate disclosures of the SEC Whistleblower Reward Program. What do you all think the impact will be of the new FinCEN Treasury Whistleblower Reward Program for information about violations of the U.S. Bank Secrecy Act and AML enforcement?
Yeah, I think the program, the Whistleblower Program, and those changes that were enacted as part of the National Defense Authorization Act are transformative.
Agreed.
Are going to, have a seismic effect on, enforcement in the space. So if you, don't know anything about sanctions or AML, now's a good time to learn about it.
Yeah, let me reinforce this. There are organizations out there that need to know about AML and KYC and don't know enough. So, the large financial institutions, the JP Morgan Chases, the Goldman Sachs, they got it. They got all their systems in place. All right. And, many of them wind up being sanctioned with some frequency. They have their systems in place. They're lousy systems and they don't implement them appropriately. The costs of these systems can be astronomical. The need to find up-to-date software that, as a practical matter, allow you to comply without imposing huge costs on the organization, it's a tremendous issue. And if there's one area where I really do see a pervasive knowledge gap, right, in some but not all sectors of our economy, this is it. And the opportunity for appropriately positioned whistleblowers to make large amounts of money by reporting AML and KYC violations in certain sectors of the economy is, I think, remarkable. And there's going to be a lot of pain in this space because there are going to be a lot of corporations that are going to be behind the whistleblowers, and there's going to be very low-hanging fruit in terms of enforcement proceedings that can be brought against violators. I don't know, Aisling, Steve, Daniel, how do you see this playing out?
I think we're going to see really, this has already been happening, but really an explosion of the intersection of money laundering and corruption in the law, and the intersection of anti-money laundering and anti-corruption compliance. And I think that those two concepts really need to be linked in people's minds. I think one practically transformative aspect of the NDAA, as Steve mentioned, is now the ability of US prosecutors to gain access to foreign bank accounts, which again is going to have an incredible effect on both FCPA investigations and money laundering related investigations. As I mentioned earlier, FinCEN has declared corruption one of its money laundering priorities. I think FinCEN in general is ramping up and doing a lot of things, including this whistleblower program. So I think that this is going to be a huge, huge, huge area. And in particular, I think the intersection of corruption and money laundering and AML, ADC is going to be critically important.
Kristen?
Great. If we have time for one last question here, and I'm curious if anybody's actually seen this in practice, but what do you do if you do an early self-report and then during the ongoing investigation find it was actually based on false information? Can you withdraw the report? Are there any other complexities there?
Yeah, you can't. Once you self-report, if that prompts an investigation, you can't go back and say, never mind. It's just a risk in, early self-reporting. Obviously, if people have made false claims, that obviously can have a significant impact. If somebody's misled the agency, that could be, violation of law in and of itself. But I don't think you get to undo the self-report.
Yeah, but on the other hand, Steve, isn't it the case that you go and you self-report, and what you say is, look, this information is early. We have no idea whether there's credibility. We've gone out, we've hired Ashling, because nobody'd hire you, Steve. We've gone out and we've hired Ashling to do an investigation. All right, and we're going to let you know what we find with Ashling. So Ashling goes off. 6 years later, we go back to the SEC, and we say, Ashling has spent 6 years trying to get to the bottom of this. Here's what we found. Here are our files, here's our investigation, here's full access to everything we've determined. All right, we think there's nothing there. And, in my experience, if you've done the investigation appropriately, you're fine. The risk is they say, Ashling looked at the people in Nigeria, but she didn't talk to the people in Ghana. So we want Ashling to go back. So what you're doing as a practical matter is you're giving the SEC an element of authority and control over how you're going to do the internal investigation to get them to a point where they agree there's nothing there. That, to my mind, is the real risk in a certain sense of going in and self-reporting. You lose control over the process. And, again, if the report is the problem is in Nigeria, and you say, fine, we'll investigate Nigeria, and the SEC says, nah, you should have looked at Ghana too, you got a problem.
And there's also, don't discount the fact personnel is policy, and there's just going to be different reactions depending on who you're talking to across the table.
Exactly. So going in and self-reporting is not costless. You're opening yourself up to a certain set of risks, but not going in and not self-reporting is also very risky. And again, as I suggested earlier on, if you reframe the conversation by saying, let's begin with the presumption we're going to go in, we're going to self-report, here are the risks we're going to take. Now, talk us out of it. It's a very, very different conversation.
And the other thing that I would caution is it's one thing to go in on an early self-report and convey the facts as you know them, and they're limited and they may turn out to be incorrect, but you better make sure you are accurately and completely conveying the facts as you know them, right? Because you can't go in and say it's Nigeria. Nothing will evaporate any credibility or credit you've built up faster than if you go in on Nigeria and it was also Ghana and you chose to only say Nigeria, right? So it's one thing if you go in not knowing all the facts. It's one thing if you go in and your initial facts are wrong or mistaken after further investigation. Sometimes the picture is better, sometimes it's worse, sometimes it's just different. But if you're undertaking to go in, you have to be sharing what you know, and you need to make sure that you're doing that fully accurately.
Ashling, you're absolutely right. All right, because if you go in and you start playing those games, this is a credibility game. You have to say, people are coming in and they're accusing you of corruption, and the last thing you want to do is be corrupt in your reporting of corruption. That's not a good way to build confidence and trust.
Joe, sorry to cut you off, but we are at time. A huge thanks to all of our speakers, to Sullivan and Cromwell for supporting our FCPA clearinghouse, and to all of you for joining the event today. I hope you have a good afternoon, and I look forward to seeing you at the next Frog Center event.
Thank you.
Thanks all. You guys were great. Thank you.
Thank you. Thank you.